Welcome to the Institute of Advanced Legal Studies. If you haven't been here before, welcome to you, old friends who know the place. My name's Jules Wilton. I'm director here at the Institute. And anyway, to get down to business, I'd like to introduce our speaker, Dr. Kirsten Sellars from the Chinese University of Hong Kong, who's one of a wonderful band of people who lend their time to us by being visiting fellows here for a period of time and lending us their expertise. So thank you enormously for that, really. Dr. Sellars' way into academia came through journalism and by writing for various eminent publications, Times, Guardian, New Statesman, and more recently he's been publishing very substantial academic works, and I'll just mention a couple of them. Her latest monograph, Crimes Against Peace in International Law, published by Cambridge University Press, and an edited volume also by CUP, Trials for International Crimes in Asia. And she's going to speak to us today on something that I'm going to be fascinated here because I don't know very much at all about it, the South China Sea arbitration and its critics.
Thank you very much. Thank you for a very generous introduction, and I'll dive straight into this subject. But before I do, in 1944 the English jurist James Brierley said this. He said, if we're dissatisfied with international law because it's failed to produce a peaceful world, then we're asking something of law that it cannot give us. The phrase law and order inverts the order of priority. Law cannot create order. Order has to exist for law to take root in. Now it's with this thought on the character of the law and our application to the sometimes not very orderly oceans that I'd like to look at the recent tribunal, arbitral tribunal on the South China Sea, responding to complaints that had been made by the Philippines that the People's Republic of China had been violating the UN Convention on the Law of the Sea. Now, along the way, when I'm talking about this, I also want to highlight some revisionist tendencies that are beginning to emerge in relation to the Convention on the Law of the Sea itself. Revisionist tendencies that have been pursued by the tribunal and also by China in its response to the China tribunal. So we're looking here at the rewriting of law. Now, when the tribunal was considering the Philippines submissions, it was operating under two jurisdictional restraints. The first of these restraints was a general one, which is that it could not decide questions relating to land, because land is not covered under the Convention of the Law of the Sea. The second restraint, and this is much more particular, is that when China ratified the UN Convention, it agreed to submit to compulsory dispute settlement, but with exceptions which were invoked under Article 298 of the Convention. And one of these exceptions that it invoked was that in the event of a dispute with a state that involved overlapping maritime claims, China would not accept sea boundary delimitations. In other words, it would not accept a tribunal in the event of a dispute and overlapping claims would not accept the court's jurisdiction. Now, in parentheses, I should say that invoking exceptions under the Convention is not unusual. There are 31 states that have invoked exceptions, some of them on grounds of sea boundary delimitation, other exceptions on grounds of military activities, including the United Kingdom. So this is not unusual that China had done so. Well, how did the tribunal proceed? China's preclusion of the sea boundary delimitations was a stumbling block precisely because there were overlapping claims between the Philippines and China. You have on the one hand the Philippines claiming a 200-mile exclusive economic zone, and you have on the other hand China laying claim to the entire Spratly area. And so you have an overlap of these two competing claims. And it was in response to this problem that the tribunal took a very radical step. It said that instead of declining jurisdiction over these overlapping claims, what it was going to do is it was transferring all these features in the contested area, was transferring them from being islands to rocks. Now, the significance of this decision relates to their respective maritime zones. Islands generate territorial seas, a 12-mile territorial sea, 200-mile exclusive economic zone, a continental shelf, whereas rocks do not. So here's the kicker, that by declaring each and every purported island in the contested area to be a rock, the tribunal effectively shrank the maritime zones from 200 plus miles to 12 miles. Now, the significance of this is that the shrinkage removed some of the overlap between the Philippines and Chinese claims, therefore enabling the tribunal to bypass China's exclusion on sea boundary delimitations and giving itself a green light to consider the Philippines' submissions. Now, the question for us is whether the tribunal's decision on islands and rocks was absolutely unassailable. And my argument is that it was not. Now, I'd like to look at what the Convention says on the subject of islands and rocks. Here the Convention sets out three phases. First, it defines an island. It says it's a naturally formed area of land surrounded by water which is above water at high tide. Second, it sets out the maritime zones of islands, the territorial sea, contiguous zone, exclusive economic zone, and the continental shelf. And third, it offers us an exception, the non-rocks. So the rocks are those which cannot sustain human habitation or an economic life of their own, so they do not have an exclusive economic zone or a continental shelf. So it doesn't say it, but what effectively it's telling us is that rocks are the poor cousin of islands, and all they have is a 12-mile territorial sea. Now, the tribunal takes as its starting point this exception, setting out here, rocks cannot sustain human habitation or an economic life of their own. And what it does is it flips the idea, it inverts the idea. It says, if rocks cannot sustain human habitation or an economic life of their own, then islands must be able to sustain human habitation or an economic life of their own. So what they're doing is they're moving this exception up into the definition of an island. Now, this does not appear like that in the article, and it is contrary to the intent of the negotiators of the UN Convention on the Law of the Sea. When they began their discussions of this, they first of all tried to define what islands were. And they were trying to find a distinction between islands and rocks, but actually both islands and rocks are naturally formed areas of land surrounded by water which is above water at high tide. So what was it that was distinctive about islands that would set them apart? So they tried various formulas. They said, could you do it according to the size of an island? Is there a minimal size of the island? They did it according to the population numbers. They would say, is there a minimal number of inhabitants of an island which would set it apart from something else? They argued that it might be something to do with the remoteness from a coast. And a number of nations made the point that perhaps you could categorise rocks and islands according to whether they belonged to colonial powers or not. So islands were free, independent and sovereign, whereas those under colonial tutelage would be considered as rocks because the beneficiaries would be the colonial powers, and therefore they wanted to exclude that from a possibility. But the problem that they faced was a fundamental one, which is why should one distinguish sovereign territories which happen to be on a mainland and sovereign territories which happen to be islands? And so it was at this point that they abandoned the attempt to consider the distinction between rocks and islands. And this is why, beyond this shared definition, there is nothing there. They deliberately decided that they were not going to make any further specifications of islands. So the tribunal moving this definition, which is a negative definition, up to Article 1 was contrary to the intent of the negotiators. So how did they proceed with this? Well, the tribunal decided that once it defined an island as sustaining human habitation or an economic life of its own, they imposed this human habitation test on the various features in the contested areas. And what I'd like to do is to follow in the tribunal's footsteps in order to understand the logic that they are attempting to impose. Now, this is one of the major features of the Spratlys. None of them, I mean, they're all tiny. This one is one of the major ones, the most, and because it's the largest, it is the most obvious to pick on, known as Itu Aba, or in Chinese, Taiping. And the first thing that, if one was going to impose a habitation test, the first thing that you would look at is, are there long-standing records of human habitation? And in relation to Itu Aba, there are indeed many of the sources that I'm using here were in the tribunal's award itself. So if we go back over the last century, back to 1918, exactly 100 years ago, at that point a Japanese guano mining company set up in Itu Aba, and it stationed some 600 Formosan workers there to work the guano mines. That mining company withdrew in 1929, then two more moved in 1937, and then 2 years after that, in 1939, the Japanese, anticipating that there might be a war in the region, assumed control of it on its own behalf. And over the course of the war, there were garrisons of Japanese troops on Itu Aba. After Japan's defeat, the Republic of China occupied Itu Aba, then withdrew, and then in 1956, the Taiwanese resituated a garrison on Itu Aba. And that garrison, which has between 200 and 600 soldiers, depending on the time, continues to occupy Itu Aba today. So we're looking at a closed military island. Now, what I'm getting at in giving all these examples and dates is that, with the exception of a couple of missing years in the 1930s and 1950s, Itu Aba has been continuously inhabited over the past century. And even in the kind of gap years, if you like, there is a lot of evidence of human habitation. So at the National Archives at Kew, there's a report by HMS Dampier that called in to Itu Aba in 1951. This is one of the gap years. And it discovered on Itu Aba 70 people, Filipinos and Chinese, lots of evidence of economic activity. There were 5 motorized fishing vessels, 12 prahus with outriggers, 4 sampans, a dhow, as well as all the detritus of former human occupation, including reinforced concrete buildings, 2 water tanks, 2 wells, a concrete jetty, some graves, a gun emplacement, a light railway, an air raid shelter, and an 80-foot observation tower. So if this was a rock, and this is what the tribunal was telling us it is, then even in its downtime, it was a pretty busy rock. Okay, so this is our first habitation test. Now the next question we might ask is, did the feature have the physical capacity to sustain human habitation in its own right? In other words, getting away from total reliance on ships arriving and bringing supplies. In other words, did those mining companies and the garrisons have sustained at least some of their personnel, and we know in 1920 it was 600, it's around 600 now, could have sustained them on Ituaba's own water supply and supply of food? The answer to this question seems to be yes, and again I'm citing material from the award. It reports that in 1919 and 1994 the well water on Ituaba was of good quality. As for the capacity to produce food, as well as the availability of sea catch, such as seabirds and turtles and fish, the feature is also capable of supporting crops. So a 1933 report suggests that the Japanese guano miners had left behind them fine palm fields, pineapple fields and sugarcane fields. And today, with the satellite images that we have here, this one from Google Earth, this shows what looks to be extensive vegetation and tree cover, which signals agricultural capacity. So this suggests also that Ituaba can sustain human habitation in its own right. Well, what did the tribunal conclude based on all of this evidence? Well, we find the answer to that in a crucial paragraph. And the first sentence here tells us the following. It says, the principal features of the Spratly Islands are not barren rocks or sand cays devoid of fresh water, but can be dismissed as uninhabitable on the basis of their physical characteristics alone. So if you stop reading there, you think that what the tribunal is going to do is to go on and argue that Ituaba has the capacity to sustain human habitation and must be an island. But then in the following sentences, it makes the opposite point. It flip-flops. It says the features are not obviously habitable. Their capacity even to enable human survival appears to be distinctly limited. In these circumstances and the features that fall close to the line in terms of their capacity to sustain human habitation, the tribunal considers that the physical characteristics of the feature do not definitively indicate the capacity of the features. Now, this decision about islands and rocks is important because it's the prerequisite for the tribunal's mandate to decide on the Philippine submission. So one would have expected it in this paragraph to have expressed itself with great force and clarity. But actually what we get in paragraph 616 is vacillation. It says on the one hand that the principal features are not obviously habitable, but on the other it says they can't be dismissed as uninhabitable. Well, which is it? On the other hand, it questions their capacity to enable human survival. On the other, they point out that they're not barren or devoid of water. Well, this is all very unconvincing, and it smacks of equivocation, and it is signalled by all these telltale equivocal phrases: not obviously habitable, appears to be, falls close to the line, not definitively. This smacks of vacillation and equivocation, not force and clarity. So I'm not persuaded that this feature is a rock. But there is a question that one could ask, which is, why, despite the presence of food and water on Ituaba, why haven't humans settled permanently on Ituaba? Why don't we have Ituabans arguing their own case? Well, we might note, in this respect, that the feature has been, although the feature has been inhabited almost continuously, and by substantial numbers of people, all of them were transient. All of them were transient. So you had fishermen who would go back to Hainan, you would have the guano miners who were recruited or dragooned from Formosa by the Japanese, only present for a few years at a time. You had the troops which were conscripted or recruited, first by Japan, now by Taiwan. Currently they serve on a 3-month rotation. So the question is, why didn't people make Ituaba their home? Well, the tribunal raises this issue in relation to paragraph 549, although it fails to follow through the logic of its own argument. It says the tribunal should consider whether there is evidence that human habitation has been prevented or ended by forces that are separate from the intrinsic capacity of the feature. War, pollution and environmental harm could all lead to the depopulation for a prolonged period of a feature that in its natural state was capable of sustaining human habitation. Well, let's apply this test to the case of Ituaba. The tribunal here lists 3 examples: war, pollution and environmental harm, and I'll focus on the first one, on war. During war, people might not be able to settle an island for a prolonged period because it is occupied by military forces prepared to take lethal action to ensure that that does not take place. Now let's apply it to the Spratlys. Although there's been no full-on conflict since 1945, the situation has been identical to war as far as settlement is concerned. Humans can't set up their home in Ituaba, even if they wanted to, because since 1956 it has been a garrisoned island within a closed military zone, occupied by forces not averse to firing on interlopers. And this has happened on a number of occasions, with the Filipinos claiming that every time they go anywhere near Ituaba, someone shoots at them. So if potential settlers had shown up, they would have been escorted out of the area at gunpoint. So that is the reason that Ituaba has not been permanently settled. We may not have a situation of war, but we do have a situation analogous to that. And it is this question that the tribunal failed to consider. So some conclusions on this. Was the reasoning of the tribunal on rocks and islands impeccable, which is obviously necessary if one is going to credibly claim to uphold the rule of law in the oceans? My argument is that here it is not persuasive. And instead what is happening is that the tribunal is conveying the unfortunate impression that it was straining to classify the features of the disputed areas as rocks in order to give itself the mandate to consider many of the Philippine submissions. Well, the immediate outcome is that it found overwhelmingly in the favour of the Philippines, and not only that, it tipped the balance against China and clipped some of the other claimants in the area, including Vietnam and Taiwan. But what's been the consequences? Well, we know that China, they did not attend the proceedings. They were very unhappy with the outcome of the proceedings. China has now produced probably the most sustained and substantial articulation of the Chinese position earlier this year, in May this year. So the Chinese Society of International Law published a book-long piece entitled The South China Sea Arbitration Awards, a critical summary. And if one were to kind of sum it up in a few sentences, it argues that the tribunal did not have any jurisdiction over any of the claims, and on the substantive questions, it offers a sort of point-by-point rebuttal of the tribunal's findings. And these Chinese criticisms fit under 3 main headings. First of all, that the tribunal was wrong in denying China's claims to historic rights in the South China Sea. Second, that the tribunal was wrong in holding its maritime activities to be unlawful. And third, that the tribunal was wrong to ignore the legal status of China's outlying archipelagos. Now, the argument about the outlying archipelagos is a new one. It's a novel argument, and it's the one that I'd like to spend most time on when looking at the Chinese position. Now, the Chinese society claims that China, a continental state, possesses 2 outlying archipelagos which are relevant to the dispute with the Philippines. And I know you can only see this map in sort of blurry outline, but one is the Nansha archipelago, which incorporates the Spratly Islands, and the other is the Zhongsha archipelago, which incorporates another area of controversy, Scarborough Shoal, and extends as far as Macclesfield Land. So there are two main archipelago groups being claimed here. Now if, and it's a very large if outlying archipelagos had the same entitlements as those which accrue to archipelago states, such as Indonesia or Fiji or indeed the Philippines, then they would be entitled not only to archipelago waters between the various features, but also beyond the baseline that encloses the entire archipelago, they would also be entitled to a territorial sea, to an exclusive economic zone, and to a continental shelf. So these are substantial claims that are being made here. Now this presents us with a problem. It's a very alluring scenario for China, but the difficulty is that the UN Convention does not permit continental states to claim outlying archipelagos as units. It does, if you have sovereignty over an island within an archipelago area, then the island will generate maritime entitlements, but the unit does not, under the UN Convention on the Law of the Sea. And so consequently, there is no reference at all in the Convention to outlying archipelagos, and this omission is absolutely deliberate. So just a little bit of backstory on this. At the Third Law of the Sea Conference, 72 to 83, Canada, which was a continental state with an outlying archipelago in the Arctic, proposed that outlying archipelagos could be claimed as units. And Canada was supported in this by a number of other states with outlying archipelagos. Colombia, with San Andres and Providencia, Ecuador with the Galapagos, India with the Andamans and the Nicobars, Portugal with the Azores, and Spain with the Balearics and the Canaries. There are a number of other contributors to the debate as well, but not, one has to note, not China. Now this proposal at the Third Law of the Sea Conference ran into strong opposition, 2/3 to 1/3, with the opposing states made up of states that did not have outlying archipelagos and led by the maritime powers, the Soviet Union, the United States, France and Japan, all of whom argued in different ways that if such claims to outlying archipelagos were admitted, the high seas would simply be gobbled up by these very extensive claims. So the Americans used the example of Greece. They said that if Greece were to claim outlying archipelagos in the Aegean, that would pretty much ensure the loss of the Aegean to the high seas forever. So they were very conscious of wanting to maintain, to maximise the high seas in order for them being able to move their own navies, fishing fleets, merchant marine and all the rest of it from sea to sea. And they did not want a further encroachment into the high seas by these claims, continental states' claims to outlying archipelagos. The final bit of heavy-duty work, heavy lifting, was at the behest of the Soviet Union. The Soviet Union made sure that a reference to archipelagos belonging to continental states was deleted, and it also changed the heading of the particular section. And you still see this in the UN Convention, from archipelagos generally to archipelagic states. In other words, the only entities that could lay claim to archipelagic status were those island archipelagos such as Indonesia. In other words, they were precluding continental states from making further claims to outlying archipelagos. Well, how does the Chinese society get around this thorny problem? Well, instead of trying to rewrite the UN Convention, it calls on the law from another source, which is customary international law, which, according to their reading of the issue, accepts what the UN Convention denies. Although the Chinese society didn't say it quite like that, it said The regime of continental states outlying archipelagos as such are not dealt with in the Convention, perhaps suggesting that it was an oversight rather than a deliberate exclusion. But it then goes on to say that it has been well established under customary international law. Now this claim to customary international law, which, as we recall, is binding on all states except for persistent objectors, is a rather grand one, and it suggests that the international community, through its international practice, has overrun the intent of the negotiators of the Convention by embracing this idea of outlying archipelagos. But then when the Chinese society gives examples, you can see that actually the content for custom is not there in the way that they've claimed. It states, for example, that some 17 countries have drawn baselines around outlying archipelagos, but there's a bit of vagueness over where some of these purported archipelagos are. And there is also an example of an overlap, which intrigues me, and I must find out more, which is that both the UK and Argentina have drawn baselines around the Falklands/Malvinas. So the logical corollary presents us, the legal corollary presents us with an interesting problem. Having said that, the issue of outlying archipelagos is not simply drawing baselines around the outer scope of an archipelago, but also claiming the maritime zones which radiate outwards from those baselines. And it is here that you begin to see the weakness of this case, because the Society cites only 2 examples where claims to both archipelagic waters and territorial sea, exclusive economic zone, continental shelf have taken place. One of those examples is Denmark in relation to the Faroes, and the other example is Norway in relation to Svalbard. So we're presented with sort of enticing scenario, but when you look at the content of what has been presented as state practice, as a support of customary international law, you realise that in fact it's not there. Well, we've had 2 examples of revisionism. On the one hand, you have the tribunal rewriting the definition of islands against the intent of the original negotiators. On the other hand, you have the Chinese calling on custom to support its claim to outlying archipelagos. Again, another idea that was repudiated by those who put the convention together. But is there a final example of both the tribunal and the Chinese trying to, and I'll say it politely here, trying to clarify the convention on a single issue? And the answer to that is, yes, there is. Now, the issue arises in relation to the Philippines' submission that the Chinese had unlawfully prevented Filipino fishermen from pursuing their livelihood by interfering with traditional fishing activities at Scarborough Shoal. And the tribunal gives an example of this. It says, in June 2002, China had deployed 28 utility boats across the southeast entrance of the shoal and had rigged them together by rope to establish a makeshift boom or barrier, therefore preventing the Filipino fishing vessels from entering their fishing grounds. Now, Scarborough Shoal is an interesting example. As we already know, the tribunal has decided that all the natural features above water at high tide in the contested area of the South China Sea were rocks, not islands, generating only a 12-mile territorial sea. This included Scarborough Shoal. This is a photograph of one of the outcrops of the shoal. It's a photograph that I nicked from the Independent, and where you can see a demonstration taking place with 3 Filipino congressmen getting onto an outcrop in the Scarborough Shoal. But I think it's pretty clear from this that it is a rock, that the tribunal didn't go far wrong with that. It is obviously incapable of supporting human habitation or an economic life of its own. Now, the confrontation between the Chinese and the fishermen took place within the territorial sea of the Scarborough Shoal, but the problem for the tribunal is that even though the UN Convention covers habitual fishing in the exclusive economic zone and traditional fishing in other states' archipelago waters, it says absolutely nothing about traditional fishing in other states' territorial seas. And the reason for that is that most states don't allow it. You're not allowed to go into someone else's territorial sea and put a net over the side of the boat. And so what we have in the convention is a very strong endorsement of a state's sovereignty over the territorial sea. It is total sovereignty with just one qualification, and that is known as the right of innocent passage. Under Articles 17 to 19 of the Convention, ships of all states may traverse the territorial sea, provided that the passage is continuous and expeditious. In other words, you have to keep moving through the sea in order to have access to it. And that it is not prejudicial to the peace and good order or security of the coastal state. And it then lists a whole run of examples of what might be prejudicial to the interests of the coastal state. I know you can't see it, but I'm illustrating here how many examples there are. Any exercise or practice with weapons of any kind, any act aimed at collecting information to the prejudice of the defence, of the security, the launching, landing and taking on board of any aircraft. And we get down to number I, Article 19, 2I, any fishing activities. Any fishing activities. So the idea of fishing in the territorial sea of another state is absolutely precluded under these conditions of innocent passage through the territorial sea. And if we want a recent example of that, we need look no further than last month's scallop wars between Britain and France, where the most egregious charge against Britain is that its scallopers had been, its dredgers had been sneaking across the 12-mile limit into French territorial waters and stealing France's scallops as a consequence. So you can see here that even though there's a David and Goliath situation with, on the one hand, the 28 boats belonging to the Chinese Navy, and on the other hand, some Filipino fishermen, which kind of indicates the relative strength, that actually when the Chinese say that they were acting within the law, then it becomes more difficult to challenge it when you look at, you put this in the context of the provisions of innocent passage. Be that as it may, the tribunal found that China had unlawfully prevented fishermen from the Philippines from engaging in traditional fishing, and they did so by elaborating on the convention. They decided that fishing within the territorial sea was permitted. They provided that this fishing provided, and this is the conditions that they imposed, that the fishing was traditional, in other words, long-standing, and of an artisanal nature. They didn't define artisanal, but they contrasted it to industrial. In other words, the implication being that these were simply people trying to fish for their livelihood. They weren't part of a kind of broader industrial concern. Now, for me, I find that morally compelling. As the tribunal pointed out, there are certain cultural patterns which are extremely fragile and deserving of protection, and who can begrudge traditional fishing folk returning to their fishing grounds in order to earn a livelihood? But in legal terms, the innovation introduced by the tribunal is very significant because it inserts a minor fracture into a major building block of the law of the sea, which is the concept of the territorial sea and upholding of state sovereignty, despite the caveat that is presented to us by the right of innocent passage. So this is a major revision on what appears to be a minor element of the Philippines case. It's a very significant encroachment into this kind of regime which has been set up under the UN Convention. Now, how did the Chinese society respond to this? And I'll conclude with this point. They argued that the affidavits produced by the Philippines indicated that the Filipino fishermen had only begun fishing at Scarborough Shoal since 1982. And they concluded that the time period of the fishing activities is short and does not constitute an extended period of time so as to give rise to a tradition. In other words, for the Chinese, tradition means something longer than 36 years that go back to 1982. Now, the problem for the Chinese is that if you get into any discussion about the duration of a fishing tradition, it's likely to work against them. Because if we go back to the debates that took place about the duration of historic fishing rights, which was the earlier formula that we find in 58 and 1960, you will find then that 36 years is a very long time. At those two conferences, the earlier Law of the Sea conferences, the maritime powers wanted the fewest possible restrictions on their fishing in other states' waters, so they proposed the shortest possible time for the accrual of historic fishing rights. In 1958, for example, the United States suggested that a state could fish in another state's fishing zone in perpetuity, provided it had fished there regularly for a period of 5 years. 5 years. So as far as the United States is concerned, traditional fishing rights have a sort of, you can build it up to the maximum required in 5 years, whereas for the Chinese, 36 years is below the minimum. So we've got a disconnect here between perceptions of what is acceptable. Now, the ghost of this discussion appears in Article 51.1 on archipelagos, which says that an archipelagic state shall recognise traditional fishing rights. So if the Chinese want to pursue their argument about outlying archipelagos, they may find themselves in a situation where it is illegal, with a strict reading of the convention, it is illegal for the Filipinos to fish in territorial seas, but it is not illegal for them to fish in archipelagic waters. So there's an irony here. So what do we think about the legacy of the award? There's been revisionism, there's been controversy, the controversy rumbles on, but we might take cognizance of one event that took place 4 months after the award was handed down. And this is where the Philippines President Duterte travelled to the Beijing, where he was keen to establish stronger economic and strategic relations with the Chinese. And so he gave a press conference when he arrived in Beijing, and he remarked of the reward. He dismissed it as been saying it was just a piece of paper. So with James Brierley in mind, order, and here it's political order, economic order, comes before the law. Thank you very much.